Welcome back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime. We are in the middle of a lunch break in the trial of YNW Melly. He is the South Florida rapper known by his legal name of Jamel Demons. He's accused of 2 counts of first-degree murder for the October 2018 deaths of his 2 friends and YNW members, YNW Juvie, who was Chris Thomas Jr., and Anthony Williams, who went by the stage name YNW Sack Chaser. We're taking your questions during this lunch hour, as we always do, so keep them coming to us on Twitter, Facebook, YouTube, Instagram, and TikTok, and we'll get to as many of them as we can. Joining us now is Bridget Williams. She is a defense attorney. Also with me is Linda Kenny-Bodden, a defense attorney and Law and Crime host, and Law and Crime's Terri Austin, who is down there at the Broward County Courthouse for us covering the case. Our first question, and Bridget, I'll bring this, throw this one over to you. Our first question right now is Hasco Vlogs from YouTube asking, they just need him in the location of the scene to convict him, right?
Well, the thing is that, again, the phones are the records and what the witness is testifying to. He is testifying as to where the phones are located. And that does not necessarily mean this is where Melly was. This does not mean that is where he was at, exactly. And so I would say, no, not exactly. That's not all they need. We know that he was already in the car, right? We saw him getting in the car at the beginning when they were leaving the recording studio. The issue here is, when did he leave that car prior to the victims getting shot? If he did leave the car before the victims were shot. And so we're looking at the time frames here, not necessarily was he there, was he or not.
Mm-hmm. There are a lot of pieces of the puzzle in this case. The surveillance video, the cell records, the differing stories of differing witnesses, and the co-conspirator in this case. Our next question comes from Diana Shields from Facebook. Terri, I'll throw this one to you. Why did the DA, meaning the district attorney in Florida, it's the state attorney, in that county, put this prosecutor on such a high-profile case?
Well, sometimes you get the luck of the draw. I mean, I think this prosecutor probably prepared for this case, but she wasn't prepared for, I think, a defense team that really does have all of the information that they need to proceed forward and to make the objections that they are making. So the defense is not making it easy for the prosecution. They are doing their homework. They are putting in the cases. And I think the prosecutor is doing the best she can with what she has. I think the biggest mistake, Anjanette, that she's made so far is to not turn over the discovery. You mentioned it before. It's an unforced error. It's something that probably someone who is new would be doing. I don't know how long she has been in that prosecutorial office, but frankly, I think that was probably her biggest mistake, and hopefully she'll learn from that.
And I think it is a formidable defense team, and you can tell David Howard is prepared for just about anything. I mean, he's very good. You can tell he's this is not his first rodeo. Our next question is from Dior Kennedy 745 from YouTube. Linda, is there such a thing as a surprise witness? If so, what's the procedure to bring that testimony in?
Well, there can be no surprise witness from the prosecution, because we don't try cases by surprise anymore, like you would see on TV and maybe the old Perry Mason shows. Everything is regulated. Prosecution has to turn over all items, and you'd be surprised in how many cases, Anjanette, they do not. That's why we have innocent people that are convicted, and we find 20 years later that there was something in the file that was exculpatory, which means that the person was not guilty. So there can be no surprise witness, but if a new witness came in that no one would have an idea would be coming in, then the prosecution would still have to give notice, and the defense would have time to prepare for that witness, but that's usually not the case.
Our next question, Bridget, I'll send it to you. It's from Twitter. @Nat asks, if Melly does get sentenced to death, will he have a chance to speak his last words for the courtroom for his fans?
I think that he definitely will be able to do that. That's up to the court. The judge will make some, words and allow for him to be able to do that. But the first threshold is getting over if he's going to be found guilty, and that's where we are now. And if he is, then we move on to that step. And if that is the case in a sentencing or anything at that time frame, then the court will make the announcement that allows for him to be able to have any last words, or if he wants to say anything to his fans or to his family.
And it won't be last words. Let's say he is ultimately convicted and he is sentenced to death. I mean, he would be able to speak, obviously, anytime he wants in this trial. He can take the stand to testify in his defense case in chief, or he could speak in the mitigation phase. We just don't know if he would choose to do that, but it would take years and years because there would be so many appeals in this case. Dior Me, yes.
The Florida Supreme Court has just stayed 2 death penalty cases in the penalty stage as a result of the 8-4, just happened last night, as a result of the 8-4 law that Governor DeSantis signed. So if this case even got a conviction, there'd be a question whether or not the defense team would apply for a stay and whether it be stayed.
Oh, and that could definitely happen. Thanks for adding that, Linda. Our next question comes from Instagram. It's from Dior_me_me. Terri, is the cell phone evidence debunking Melly's statement that he wasn't in the car at the time of the shooting, but cooperating with deposition of Miss Felicia Holmes' statement of the FaceTime call?
Well, that's an excellent question. Right now, the witness has not put the car at the scene. One of the things I think the prosecution will have to do is to get information from the car that car is at the scene. The cell phone data just means the cell phone was at the scene. As a matter of fact, it doesn't even mean Melly was at the scene because the phone could have been carried by anyone else. So I definitely don't think that it's a problem, anything Melly may have said at this point, because the prosecution hasn't proven that Melly was at the crime scene, that he was holding the phone, or that he was in the car. The only thing they are showing right now is the location of the cell phone, all of the cell phones, frankly. And so I think we do have a ways to go to actually say that Melly is the one who did the shooting, he had the gun, he was in the car. Long way to go before that.
Bridget, this next question I'll send over to you, also from Instagram. 543 Ina asks, hi, tuning in from Australia. Thank you, Australia. We always love it when we get questions from different countries, and we do get a lot of Australian viewers. My question is, will the jury look at YNW Melly behavior, happy, giggling, goofing around, etc., and take it as there is no remorse, therefore he is innocent? Or will it backfire on him, and the jury will the jury take it in a negative way, Bridget?
Well, we never know what jurors are thinking. However, as a defense counsel, it's our job really to let the defendant know before a trial, before a hearing, before any matters before the court, to take it seriously and to make sure that they are on their best behavior. Melly has been quite the character throughout this entire trial. He mouths words to people in the audience. He says prayers. He gives kisses in the air. I believe he was said on his social media that he was giving kisses to angels, is what he said on his social media. And so if I was his defense counsel, I would have nudged him at that very moment to stop it right at that time. I also would have had a conversation with him prior to trial to make sure that he is being in a serious manner, that he's also showing that he's taking this seriously. You just don't want the jurors to think anything differently. You want them to make sure that they think that this is serious to him. I mean, he's being tried for a double murder case and, could be sent to death here. And so it's a very serious offense.
It's as serious as you can get in our criminal justice system in the United States, and really in any country for that matter. Our next question comes from Alex A. from YouTube. What does hung jury mean, Terri Austin?
A hung jury is a mistrial. It means that they can't all come to a unanimous decision. We're in the guilt phase here, and they do have to come to a unanimous decision on both of these murder counts that we have first degree for Melly. And so if you don't have, all of them agreeing, and it can take time, these types of things, sometimes the judge has to go back and say, look, it may seem as though you have lots of questions. It may seem as though you can't come to a decision, and he might give a charge saying, go back and see if you can come to one kind of conclusion. So right now we are nowhere near the deliberation phase, but if they actually do start deliberating, and if they do become hung and that charge doesn't address the situation, then that could mean that there is a mistrial. And a mistrial simply means that they could start all over again. The prosecution would have the ability to make the decision as to whether or not they want to bring the charges against Melly again. So hopefully there won't be a hung jury, which would mean a mistrial, because with all of the effort that's been put in already, you want to see some sort of definitive conclusion to the trial.
Most certainly. Our next question, Dakota.G9, Linda Kennyboden. This is coming from Instagram. If the defense is winning at this point in the trial, how do you think the prosecutors could sway the jury in their favor if they do not have any more hard evidence or witness testimonies to provide them with?
Well, this is a really interesting question, because remember the surprise witness issue the other day, or the other question we just had? There is one thing that prosecutors may decide to do. They may decide that the devil in this case is Melly, and then go back to the attorney for Henry and say, let's make a deal. Will you testify as a prosecution witness, and we will give you a deal of whatever time served or whatever, on the basis that they feel they need to get Melly. I don't think that's going to happen, but it's always in the prosecution arsenal. They could say to the judge, the deal was just made. The defense can then move it. They'll move for a mistrial. They'll move for all sorts of motions, but the judge would let it go through.
So even that late in the game, Linda, you think the judge would allow it if they said, hey, we made a deal with Bortland, he's going to come in here now?
Yeah, I think because the deal is dependent on the attorneys, right, to accept it in the first place. So I think he would. He may put a little delay. And remember, we have that delay built into the third week of July here. So that could happen. I don't think it's going to happen, because I don't think Henry wants to be in jail or in prison being the proverbial, what we used to call snitched, or now call incentivized informant. But it's there.
Yeah. In prison, though, they still call them snitches. So he probably does not want to be labeled a snitch. It's never a good thing. All right. We are going to take a quick break. Keep the questions coming to us. They've been fantastic. Twitter, Facebook, YouTube, TikTok, Instagram. And we'll be right back. I'm Anjanette Levy, and you're watching Law and Crime.